Good afternoon. Thank you for joining us today. I'm MAPER's Secretary Treasurer, Lori Siskin. I'm also a trustee on the Oakland County Employees Retirement Board and currently chair of the City of Farmington Hills Employee Retirement System. And I'm also retired from the City of Southfield where I was the pension administrator. This webinar is specifically designed for new trustees to provide an overview of fiduciary responsibilities and best practices related to the administration of public plans. In your confirmation email earlier today, we've included a link to our website with a glossary of terms that you might find useful. I'm joined today by MAPER's attorney, Tom Michaud, whose firm Vanover, Beck, Michaud, and Timoney focuses on public employee benefits law. Please submit any questions that you have through the green Q&A button located on the Zoom app, and we will be happy to answer questions at the end of the presentation. And now I will turn it over to Tom.
Thank you, Lori, and welcome new trustees. As Lori indicated, this is the new trustee workshop. It's not limited just to new trustees though, but you'll see that the discussion points that we talk about today are really going to be at the fundamental basic level. And what we encourage all trustees, including new or senior, and when I say senior, that's not an indication of age, it's simply an experience level on the pension board. So what we consider to be a new trustee is anyone that is in their first term of office, and that could be a 3-year, 4-year. So it really does take some time for you as a new individual on a board to become familiar with the concepts. And as a new trustee, we're going to start from the very beginning. So this is what the focus is of this new trustee workshop is, and we welcome you. So welcome on board. As a new trustee, you are here on behalf of your system, and you are part of a team and a member of a board of trustees. So, normally we would do this session for new trustees, and Lori and I have been doing this for many, many terms, decades, and a long, long period of time. So the new trustees that we used to talk originally with are now senior trustees. So we're very proud of that and are happy that we are able to spend some quality time with you. And typically we would be spending time with you at a conference. And so this seminar is put on by MAPERS, this virtual seminar, to kind of facilitate the discussions that Lori and I have historically done. So as I said, normally we would be at the Grand Hotel or the Amway Grand or Grand Traverse. So it would be a grand experience. But the reality of it is you're in my basement. So welcome to the new trustee workshop. And Lori and I are bringing this on your behalf from my basement. So from that standpoint, as you can see, we're presenting the information. We can't see you though. So it's a little bit different than we've done in the past. It's a good opportunity for you to kind of relax, kick back. You could be on your phones. We're not going to know. We can't see you. So we will give you an opportunity at some point later on to ask questions, and hopefully we'll be able to present some insight to you. But you're probably asking yourself right now, how did I end up in Tom's basement? So welcome aboard, new trustees. You may have been elected, appointed, some would say shanghaied to get onto your board, but you are now a trustee. And as a trustee, you are now a fiduciary. So you may be asking yourself, what's a fiduciary? So it's going to be something that we're going to talk a lot about today. It's going to be a term that you're going to become very familiar with. And if you want to play a game, you could probably try to see how many times I say the word fiduciary today, because I'm going to be saying it a lot. So You may be familiar with the term. Oftentimes it's not something that you use in daily discussions. I know some of you probably years ago said to yourself, when I grow up, I want to be a fiduciary. And that would be great. But oftentimes that's not the case. And so what we're going to do today is spend a couple minutes in the beginning talking about what a fiduciary is, so that you don't have this look in your eyes when the topic comes up or at board meetings about what a fiduciary does. So, oftentimes as a member of the board, a new trustee, you've kind of been pushed into, I don't want to say, into traffic, but because of this slide here, it might like that case, but you're going to be a new to this system and new to the concepts. And hopefully when we get done with this seminar today, you'll feel a lot more comfortable about being a fiduciary and really understanding what's involved with that position. So, we're going to get into the definition here. So fiduciary, and what I've done, and Lori and I have kind of put some of these slides together for you to go back, when we're done and review some of these concepts. But the very, very basic fundamental concept that we're going to be talking about is being a fiduciary. So I've listed a couple of definitions and a couple of things that we're going to go through, but phonetically, we've even written it out for you. So there is no reason why you should not be using the term fiduciary on a frequent basis. So, and don't worry, it's not like Beetlejuice, where if you say it 3 times, bad things are going to happen in chaos. It really is something that if you say it, it's just the opposite. The more times you say it, the more times you remember it, good things happen. So, so click your heels 3 times together. Say fiduciary. You can say fiduciary as loud as you want right now, because once again, we can't hear you or see you. So keep that in mind. If you're ever in a situation where you find yourself in a quandary, just say fiduciary. If anything else, you'll impress your friends and neighbors. So, but what a fiduciary is somebody that is responsible to hold things in trust. And that could be assets, that could be dollars, that could be people's personal information. It could be making sure that things are done correctly, benefits are calculated correctly. It's really somebody that acts in a fiduciary capacity, means that you're acting in their best interest. So the etymology, another good word, is Latin, it's confidence. It's to hold in trust. So you should feel confident that you're acting on somebody's behalf, and they should feel confident that they trust you. So, I really did a lot of legal research on this terminology of fiduciary. I even cited my my authority as Webster's dictionary. So it's official. So that's the definition. When we look at some of the principles of being a fiduciary, one of the things we're really going to look at is the statutory language. And we're going to get into more of the statutes, the laws, the rules, regulations as we get into this. But one of the cornerstones of being a fiduciary and the language that sets out the requirements is what is commonly referred to as Act 314. So that's the Michigan Act that deals with investments, but uniquely discusses a fair amount of fiduciary responsibilities that deal with administration, as well as other things dealing with not only the assets, but the way that the plan operates. So if you look at the definition of fiduciary in Act 314, it really reflects the authority and the discretionary control over the assets. In other times, people who give advice are paid a fee. Those are plan professionals, investment consultants, managers. But really the fiduciary responsibilities are outlined in quite a detail in Act 314. So if you're thinking about where do I go to find some of this information, go to 314. Specifically, Section 13 in Act 314. So we might be throwing out a lot of numbers, Section 13, 314, 345. It's a whole different language that as a new trustee, you might not be familiar with, but you're going to get used to it. And so Act 314 is another term that you're going to get really used to over the time here. And what that does is outline specifically some of your responsibilities, your duties, your authority. And so you might be asking yourself right now, hey, listen, that font is so small. I can't read that even on my screen on my smartphone, if you're using your phone to tune in here. But it's done purposefully. So this is the section that deals with the responsibilities of a fiduciary. But you can also read this in larger font at your leisure. But it goes as a reminder of this is the detail. These are the important things that you should be looking at. But it's also a reminder that as a trustee, some of the best things that you'll see in documents are in the fine print. They're the detail, they're in the back, they're in the footnotes. And so this is just another reminder of, yes, Section 13 of Act 314 is the fiduciary responsibilities, but this slide gives you an illustration of sometimes the details of the things that you are most responsible for are going to be found in areas and in the small print, and that level of detail to look at that information is critical in order for you to understand what your roles and responsibilities are going to be when it comes to the plan. So go back at your leisure, look at Section 13 when you get a chance to do that. It's posted on the MAPERS webpage and other places. So take the time, look at this section, and it'll give you a little bit of a guideline on what you need to do as a fiduciary. So boiling it down though to its basic elements, it's the exclusive benefit rule. So you may hear the exclusive benefit rule. It really is something that is quite basic, quite common sense, but bears repeating. A trustee must act solely in the interest of plan participants and beneficiaries. So I laid this out much larger font and broke it into a couple of lines because a trustee must act. So whether you do something or do nothing, you are still acting. Doing nothing is still an act. So you need to make sure that action is paramount, and a trustee must act when you do solely in the interest of the plan participants and beneficiaries. So, from the standpoint of your action as a plan member, you're acting as a trustee and on behalf of participants and beneficiaries of the plan. So we always talk about the new trustee at the new trustee workshop level, the trustee hat. So you as a trustee are, going to be dealing with a number of different concepts, but when you come to the pension board, you're looking simply and solely as a trustee and not for how you got there, as a member of the union, as a member of the employer, as an elected official, as a retiree, as a citizen. You're acting solely in the interest of the plan participants and beneficiaries. So if you're at the table and you have a hat on, it should be the trustee hat. And if you want to talk about things, take off the hat and remember that you are a trustee acting solely in the interest of the plan participants and beneficiaries. So once again, welcome to the new trustee. Usually the orientation for trustees when they first come on the board looks a lot like this. Okay, and you'll see that the trustee has a hat on and is inundated with information. And as a board member, when you come to the board as a first time or a few times in, you may feel like this is the way you're being initiated into the world of pension, healthcare, and other employee benefit plan boards. So I could just watch this for like the next 15 minutes and that would just be entertaining in itself. But this is a trustee orientation that you want to make as smooth and as efficient as possible. And so what we're going to do is talk a little bit about the trustee wearing a trustee hat and really going through the basic fundamentals of where you start as a trustee. So I will turn it over to Lori and kind of go through, what's the plan as a trustee.
Thanks, Tom. I didn't do any of the gifts. Tom did, so bravo to you. The plan has, on this page, we're showing quite a few of the enabling documents and the documents that are important for you to be aware of when you are a trustee on a plan. And the last bullet there, employee trustee handbooks. You are very lucky if, as a new trustee, your administrator gave you a handy binder with all these documents in it, one-stop shop, so that you can really go through it very carefully and systematically in order to know what all the documents are. That may or may not have been the case, but and if not, these are some of the documents that are really important as far as being the foundation of the plan, and important for trustees to know that these documents exist and to have a familiarity with them, not necessarily read each and every one, but when it's important to, some of these really do require your in-depth familiarity with them. So we start off with statute, charter, ordinance, resolutions. The plans are developed in a variety of ways. Different communities have established their pension plans in different ways. Statute, we talk about Act 345 is a public act of the state of Michigan to establish the police and fire systems. A plan may be established by charter in your community, by ordinance, by resolution in county, and system plans, municipal plans may be a little different, but they all have an enabling plan document. And that's kind of the basis for identifying what the benefits are and how these plans are going to be managed and operated. So as trustees, you're responsible not only for administration of the plan and making sure that the employees and the retirees are getting the benefits in the plan, but also the management of the plan assets. So there are quite a few documents related to both of those. In Michigan, collective bargaining can override some provisions of a plan document. So the collective bargaining agreements, the pension benefits are mandatory subject to bargaining, and it's important to be aware of collective bargaining agreements that have language in them that affects the plan that you will be administering. For example, the plan document could say that you have a 2% multiplier. In collective bargaining, that's been changed, and it's now 2.25% for those hired after, 1180, whatever. It's important to know that it's a document you may have to go back and reference if there's a question about a plan provision. It may not only be in the enabling plan, ordinance, charter, etc. It could be collective bargaining agreements have modified. Summary plan descriptions are required to be developed and posted. That's one of the newer requirements in Act 314, and it's a summary of plan provisions and its funding and its the service providers and some of the other information required. Plan policies, we're going to talk about a little bit more detail on another page. The actuary is going to provide you with an actuarial valuation, which is an analysis of the members of the plan, the demographics, how many employees you have, retirees, their ages, how much service they have, and what the funding level is of the plan, and the long-term, the contribution rates that are going to be required to maintain that funding level. The audit reports may come, maybe this plan sponsor's auditor or the board's auditor. Different communities do it differently, but you should be getting a copy of the audit report to look at the financial status of the plan. Your legal advisors are going to give you legal opinions and advisory memos. That should be maintained, that you should be referring to when situations come up in the future, and that provide a guideline for how to operate. And the IRS qualified plan determination letters probably happened way back when the plan was developed. Hopefully you do have those, because we are operating our plan as qualified plans. One other thing that's not on here is something for a new trustee, when I was administrator, I would always try to provide a new trustee with at least 2 years worth of minutes of the board, because I think it's important to go back and review how the board operates, what topics are important to the board, what issues may have been kind of brewing so far, and it'll give you, a good basis for going forward.
All right, so Lori has given you a copy of what's the plan. It is important to get a copy of it. So you check with your administrator. As a new trustee, one of the tips you'll come to understand is that the administrator of the plan is your best friend. So get a administrator, get a copy of the plan documents Lori went through, and you'll be much better off, in terms of making your job as a trustee easier. So there are rules. The plan document will give you what the rules are. This is what you look like if you don't follow the rules. So from the standpoint of your plan document, get a copy of the plan document, follow it, because there's also a number of other rules and regulations that are part and parcel of your responsibility of being a board member. So these are not even an exhaustive list of what the rules and regulations are, but are probably ones that you're going to want to start with off the bat. Number one, Constitution. Article 9, Section 24. Once again, sounds great to just throw that out. But it sounds, what that does is it protects public pensions in the state of Michigan from being impaired or diminished. So take a look at that section. It's very important. It's the cornerstone of all the rules and regulations at the state level in Michigan. And it is of high importance. So we talked a little bit about investment of funds, public employee retirement systems, commonly referred to as Act 314. You'll be very familiar with that at some point with your investment consultant. Get a chance to take a look at that. That would be great. Thing to remember is that you are a public trustee. As a public trustee, you are subject to the Freedom of Information Act and the Open Meetings Act. Freedom of Information Act details documents are subject to review by the public, and as well as Open Meetings Act requires you to have open meetings when you are participating in board discussions at that level. We'll get a little into that a little bit later. Other ones that are similar, you'll get used to seeing more in terms of the acronyms. EDROS, Eligible Domestic Relation Order Act, PARA, Public Employment Relation Act. Those kind of things is something that you're going to get used to. But MAPERS has compiled links and information on their webpage for copies of these acts. So if you really want to go into the level of detail of looking at the state statutes, please pull the webpage details and get a copy of the act, go through it. And as always, if you have any questions, comments, or concerns, bring it to the other board members' attention, bring it to your administrators, your legal counsel, your professionals, and really get to know the rules and regulations, because people are looking at what you are doing. So compliance is critical. Oftentimes trustees will say, who is looking who is looking, who is enforcing these rules, how are these regulations being, made sure that they're complied with, is that compliance officers are oftentimes your members, your retirees, members of the public, let alone other agencies and entities. Primarily though, as a fiduciary, you're acting on behalf of other people, and be aware that other people are watching you. And as this member of the public says, learn your rules. And if you don't, there's consequences. So one of the things that helps boards follow the rules are policies that are adopted that recognize the past practice oftentimes of a system and are memorialized into written documents, which we refer to as policies, procedures, forms, bylaws. They come by different names, but they all have the same purpose: to provide guidance and rules that people understand and, more importantly, can follow. Because if you don't, this is what happens. So with that, I'm going to turn it over to Lori to talk about some of the policies that are important and some of the policies that you may have in the significance in the operation administration of your plan. Thanks, Lori.
Okay, so it's a big long list here. I'll get through just briefly to get through it. What are the important things that we want to make sure you understand, though, is that it's important to have these policies and procedures in place before you need them. Because the worst thing is to, for example, have a disability retirement before you, and there's really no policy in place to tell you what steps are going to be taken, who's going to be doing the medical evaluation, what the consequences might be if there's a denial, what the next steps are, etc. And you don't want to create a rule or a policy or a procedure around a specific situation. You want to, many times boards will have subcommittees that will work on a lot of these administrative policies so that they will be in place ahead of time and anticipate questions and issues, and work with your administrator and your other consultants to come up with policies that can operate the plan in a fair and equitable manner going forward. So examples: service retirement policy and procedures. Somebody's going to be eligible for retirement, but when can they retire? When can they apply for retirement? What kind of paperwork is involved, et cetera, et cetera. So there's many steps and processes. What kind of forms and documents do they have to submit in order to qualify for retirement? I mentioned briefly disability retirement. That can be one of the more challenging times in a board meeting in dealing with a disability retirement, where there may be some gray areas to the individual's ability to qualify for disability retirement. And it's somebody you work with every day, if you're one of the employee reps, and it can be very difficult unless you have a very strong policy and procedure in place, standard forms. This is how we deal with it. I mean, it's not just a casual evaluation. It's very prescribed and systematic in terms of how you will evaluate a disability retirement. And there's often a disability re-exam policy built into your plan. When someone qualifies for a disability retirement, plans many times indicate that they're periodically reevaluated to determine if they are still disabled under the terms of the plan. And it may be a common one is to reexaminations every year for the first 5 years, and then periodically thereafter until normal retirement age. So you do have to have a policy in place because the plan document says you're going to be doing this. So how are we going to affect getting our disability retirees re-examined? Are we keeping track of them? Do we know where they are? And what processes and steps are we going to go through? Certification of earnings policy and earnings offset. again, this relates to disability retirements, and some plans do require that the individuals who retire under a disability retirement notify the plan if they are earning wages outside once they've retired. And some plans do offset their disability pension for some earnings that they make later. If it was a duty disability retirement, they may also be getting workers' compensation going forward into retirement, and there could be an offset of the workers' compensation, or if the workers' compensation has been redeemed to a lump sum, how does that relate to the pension benefit? Is there an offset, and how are you going to calculate the redemption going forward? All these things are just not going to be, these details are not going to be necessarily in the plan document. They're going to be in policies and procedures that the board has adopted over the years and periodically reviews. Final average compensation policy, that might sound kind of easy. You're going to calculate your best consecutive 36 months out of the last 60 months prior to retirement. But guess what? Your wages were determined on a monthly basis when that was written, and now many years later, you now have a biweekly paycheck. So is the biweekly paycheck the same as a monthly paycheck? No. How are you going to translate? So there's many little nuances that happen over time in the course of a plan. Some plans are 50 or more years old, and these policies are going to be the ones that are going to update and make them current and make them usable going forward. Service purchase procedures. Some plans indicate that you can purchase additional service credit, but they may not give very much in the way of guideline or process as to how are you going to do that. It's very common to have purchase military service, but it may just say you can purchase up to 5 years of military service, and that's all it says. But the details and actually implementing that service purchase are much more complicated and require a policy. The investment policy statement is a requirement that you have in place for the plan. We're getting into investment issues with that, and it will identify the investment goals of the plan, the asset allocation, and that needs to be periodically updated, and you work with your investment consultant to keep that up to date. It's important for trustees to obtain education and being aware of what's going on in new trends and ideas in benefit administration and asset allocation policy and actuarial policies and new asset classes, et cetera. So it's really beneficial for the employees, or for the trustees, to have to be going for further education, and an education policy is important to bolster that. How often can you go? Can you go in state, out of state, et cetera? If you go out of state, is there a travel policy should be in place to identify the reimbursement for trustees? An ethics policy is also a requirement under 314, and speaks to issues like conflicts of interest and other issues, and something like we're doing today, to make sure that you understand your roles as a fiduciary. Record retention FOIA policies, those may be something that the plan sponsor already has a record retention policy. Your city clerk may have one, but the plan may also have its own record retention policy and keep its own policies separate. Its record separate, its FOIA requests would come to the plan, not necessarily to the plan sponsor. An EDRO is an eligible domestic relations order. This occurs when there's a divorce prior to retirement. And the divorce decree is not going to affect and tell the plan how to divide the pension benefit. That's going to be under eligible domestic relations order that's going to be filed with the court, and then the board will have a policy and a procedure and forms that the court needs to follow and the member needs to follow. Actuarial policy, there will many times be a funding policy that you'll work with your actuaries to determine how we are going to make sure the funding status of the plan stays solid and stays healthy going forward. Beneficiary data, keeping retirement beneficiary data secure. How are we going to obtain it? Where are we going to store it? Etc. Election procedures. Those of you who are elected reps, you were elected during a procedure that was established by the board. So how you nominate, how you distribute ballots, collect ballots, count ballots, timing of that. It's very important, again, that be in a board approved procedure so that it is consistent for everyone and there's no question.
So what we did is we put this together as a checklist and use that as a something to go back to talk to your plan and your administrator. As Lori indicated, some of these are specifically required: investment policy, ethics policy, that's legally required. The other ones just make common sense and help the system administer the plan consistent with the plan document and fill in some of the details that are oftentimes absent in collective bargaining agreements, ordinances, charters, and this gives you the level of details that you need. So I know we've gone through a fair amount of plan documents, laws, policies. It's oftentimes overwhelming for trustees, new and senior alike, but there is assistance. You are not alone, and as part of being a trustee, you do have the ability to hire and retain professionals. So oftentimes it's a legal requirement to administer the plan, and you're going to be responsible for a fair amount of plan assets. And in those instances, oftentimes it's the most prudent thing to do is to delegate and those responsibilities to other entities, firms, individuals who are better experienced and more specialized in a specific area. It is important to remember, though, that as fiduciaries, you can delegate responsibility, but you have to delegate it to somebody who is qualified, capable, and otherwise would be a fiduciary to take over that responsibility. But oftentimes, the best decision is to delegate that responsibility to somebody else. And the law contemplates that you will do that, and Act 314 gives you the authority and the ability to retain outside advisors. So as part of those advisors, you'll see that we refer to them as the A team. So Lori, if you want to maybe go through some of the different firms, entities, or plan professionals that you would typically see at the plan level.
Okay, we spoke a little bit about some of these and what they do. The actuary, as we said, will collect data from the plan, demographic data, who's in the plan, which members are in the plan, the retirees, their ages, their year, the active members, their years of service, their wages, in order to determine what their future benefits will be. They'll use information about the plan assets, the mortality tables, and come up with a analysis that will tell you how much money each year the plan needs to put, the plan sponsor needs to add to the plan in order to keep the plan running and to keep benefits in the future provided to the members. The administrator, as we said, was a very important person that's going to be handling the board matters and provide day-to-day support to the board, provide information for the members, do their benefit calculations, make sure they're getting their benefits and all their information about what the plan provides, information for the retirees if there's any issues, and then interfacing with the investment team and handling the contractual matters, et cetera, and also dealing with custodial staff if there's any issues there. The auditor could be the auditor for the plan sponsor, or it could be that the system itself has its own auditor. I've worked in 2 different situations, so it could be one or the other, but there will be an audit report in some form or another that is important for the board to be aware of. The administrative staff is going to work with the administrator, handling meeting packets, getting the meeting minutes, information ready, and also doing a lot of dealing with your employees and your members. The custodian is going to custody the assets of the plan. The investment consultant, when I first started, I was not really clear as to what the difference was between the investment consultant and the investment manager. It took me a little bit of time to really understand that those differences. But the investment consultant is working with the plan itself, directly with the plan, and will advise the board, working with the board and advise the board on such issues as asset allocation. Where should we stocks, bonds, other asset classes, alternative investments, give education to the board as to what each of those asset classes mean, how they operate, where do we want to invest our money long-term, and give guidance and assistance. And then many times assist them in finding investment managers who will actually do the investments of the funds according to this, the styles that they have represented themselves to manage. So the investment consultant will also monitor, and sometimes they are called investment monitors, and they'll monitor the performance of the investment managers and report back to the board. Our large cap growth manager had a 22% return this quarter, and that compares to the index of 21%. So they beat the index, et cetera, et cetera. And it could, but you will get quarterly reports very often from your investment consultant that will go over all the work that the investment managers have done, their results, and then discuss with you if you want to retain these managers. Periodically, you may ask the consultant to interface with the managers, bring them in for a meeting, talk with them, and have a face-to-face with them and find out something more about their investment style, anything that's changed in terms of their investment philosophy, their personnel, and keep an eye on how they are operating. Your legal counsel is, in many plans, does attend all the board meetings, not every time, but many times, and it is helpful. Even if there's no formal report from your legal counsel, there is oftentimes issues that come up during the course of a meeting that your attorney does need to weigh in on and give sound advice. We talked about medical director, and I mentioned earlier about disability retirements and how tricky they can be, and sometimes uncomfortable, and getting confidential medical records, et cetera. It's really not, it's really something that the board should have its own medical director on their team that can provide, do an evaluation of the individual, the member, and then report back to the board so that the board has the information necessary to decide yes or no for disability retirements. And then there's special consultants occasionally that board may be considering, say, a real estate investment, and they've hired a special consultant just to do a full review of their real estate investments and perhaps recenter how those are going to go forward. So there's a variety of special consultants for a variety of reasons, but altogether, these individuals are supporting the board members in providing you the information that you need to make good decisions.
Well, as you can see, there are a number of professionals, but it is important, as a reminder, to do due diligence on professionals. So you don't want to find yourself at a board table that this happens. So doing your due diligence, your research, your thorough review of professionals is very critical, because you are held to a prudent expert standard. You are evaluated, and there is a level of responsibility that you have to exhibit in your role as a trustee. And that is acting with the same care, skill, prudence, diligence that a prudent person in the same seat would be doing. It's a fancy definition, but at the end of the day, it's a higher level of review and expectations that as a trustee, you will be responsible for. So it's not at this level, but it's a high level. So you, as a prudent expert, need to be well aware of what's around you and act within your responsibilities and your plan documents in your role as a trustee, because you will be held to that standard when somebody is reviewing your performance as a board, as a plan, and as an individual trustee. As a prudent expert, that's the standard. Fiduciary standards can really be boiled down to a number of different, very common sense, broad terms, but loyalty, diligence, be prudent, diversity, compliance with the plan documents. All these things are very important. And as you'll see in that quote at the end, the difference between education and experience: education is when you read the fine print, experience is what you get when you don't. So it's important to follow the rules, follow the understandings, because as a fiduciary, you're held to a very high standard. But basically, if you understand the facts and the circumstances, work hard to get the knowledge and the education through papers, through your experience at the board level. You focus on the process and the documents, the rules. You think about the options. You seek advice when appropriate. At the end of the day, you will be doing what you're supposed to be doing as a fiduciary. And really, the terminology that you'll also hear is arbitrary and capricious. So once again, fun to say, very impressive, but it boils down to: don't make random decisions. Don't pick and choose because you like or don't like something on the decision that you're going to be making. Every decision that you should have should be able to point to a specific plan provision, a specific rule, and that's compliance. As one court put it, it's not sufficient that a trustee has a pure heart and an empty head. Obviously, you're volunteers. Oftentimes at these boards, you are working in the best interest of the plan participants and beneficiaries. You have the best intentions at heart, but you need to put some of the document in behind it. And so you don't need to be perfect, as we say, just prudent. So if you spend the time and energy on doing what you're supposed to do, I think you'll end up at the end of the day being very successful as a trustee. What you want to do, though, as well, is avoid conflicts of interest. As a trustee, you're responsible for billions and billions of dollars. And if it's not billions, it's millions and thousands. Even if it's $1, it's still somebody else's money. And as a trustee, you're responsible. And so the conflict of interest is something that you want to be aware of and manage. Something that is very, very obvious and something that you can deal with, but is oftentimes easier said than done, given the pressures and the responsibilities and the assets that you're overseeing. So once again, remember though, as a trustee, You have a lot of authority, a lot of responsibility, which boils down to liability. Not simply in the actuarial concept, but in the personal liability category. So I put this in here as a reminder that as a fiduciary, you are subject to potential issues on a personal level. But if you follow some of the things that we've talked about today, you're really mitigating those risks. Hiring professionals mitigates that risk. Following the plan document mitigates that risk. So if you keep the plan as a primary purpose and function of what you're doing on a day-to-day basis, you will be able to manage the personal, the liability, and all that will really fall into place. There is the ability to buy insurance. Go back, check with your system to see if you do have fiduciary liability insurance. It's not a free pass to do anything you want, but it is something that you should be aware of and gives you a comfort level of, you know, acting in the behalf of the trustees for your plan. Common sense goes a long way. You know, potential areas for errors. You follow these kind of things, you really kind of minimize those errors. Prepare yourself, continuing education, ask questions. Even if it's difficult to ask questions, sometimes the most difficult questions to ask are the ones that are the most appropriate. And those are the questions that if you don't feel comfortable with a concept, you really need to get more information. And if that takes a little more time, then it takes a little more time. And as trustees, you can do that and take the time that you need to make the right decision. So, because remember, as a public trustee, you're in the public. And so Lori will kind of share with you some of the meetings and the fact that you are in the public eye. So if I could then, Lori, so as a member of the public, meetings which have typically happened in person are now happening electronically, virtually, whether it's Zoom or other platforms. We've left a space in the middle there where you would generally be in an open meeting, public participant, looking at everything you're doing as a trustee. Pretend you're sitting in that middle square as a board member. And at that point, you will be subject to the Open Meetings Act. So, you know, while it's different than today, where you could be on your phone, you could be on your phone at an open meeting, but just make sure you are not conducting board meeting minutes or board meeting, because you will show up in the minutes if you're doing something else. And if you're in the video, it's something to keep your phone out of the screen sight. So that's a helpful tip at open meetings, public meetings. So you do have to follow the rules. There are rules that oftentimes people believe Robert's Rules of Order are in effect. That's not necessarily the case. And oftentimes that's not the parliamentary rule that you want to follow. So find out what the rules are from the way that the board contacts and conducts board meeting minutes, or conducts board meeting, because it will show up in the minutes, your actions. And procedurally, you really should be focusing more on the topic of discussion and less on the rules on how a motion should be made and how things in terms of activity happen at the board level. So I think when it comes down to how the procedure works, the rules of order, all trustees will be participating. And finding out what those rules are is important, and making sure everyone has an opportunity to participate, because as we said before, if you're acting or not acting, you're still acting. And the rules of order really help facilitate that activity. So as a new trustee, we want to leave you with a couple of notes here. The only source of knowledge is experience, and the experience is the teacher of all things. So, we had to go way back to 44 BC, but it was good back then, and it's still good in 2021. And just remember that at this point, this is the end of the beginning. So as a new trustee, you are beginning on a new adventure. And it is something that's very worthwhile and valuable. And we value that your input and your efforts will be well rewarded, when people go to retire and their benefit is being administered the way that they envisioned and made it happen. So we want to thank you for participating at the board levels, participating at this conference session, and thank you for playing. Any questions or comments? We will be happy to open them up. Spend as much time as you would like to go through these things. I'm in my basement and I'm not going anywhere, so we can take as much time as you want to go through that thing. And once my sons have reminded me is that when you watch a movie, that you really should stick around as long after the credits. And I think that's a Marvel thing, but it's a marvel that we've gotten through this somewhat on time, which is a good thing. But I would like to credit MAPERS, Lori specifically, MAPERS' board, the organization for bringing this to you and making this possible. But I'd really like to thank you specifically for your time and energy and attention to something that is very, very important. And with that, I'll turn it over to Lori and we'll open it up for questions.
Okay, I do have one question submitted, and the person's asking or mentioning, since COVID has accelerated technology trends, and we have a virtual meeting today. Once social distancing standards get relaxed and we're meeting within a meeting room together, do you think it's still important to physically meet with your plan consultants, or would it be beneficial or prudent to negotiate some cost savings by asking them to continue to meet virtually?
It's very important to continue the lines of communication amongst trustees, amongst staff, and amongst your plan professionals. Every board is different. Every board can operate. Some are very, very formal. Some are very informal. Some operate in small conference rooms, other in auditoriums. So it's really on what board level of communication that you can perform safely. As we've said, in the last months here, that safety is paramount and it should be a priority. If you feel that you need to continue remotely, that's something that you should do. But board members should continue to meet with their plan professionals. Oftentimes the virtual format is another way that can increase the knowledge and experience and education on an individual level, but also at a board level. You can sometimes see some presentation materials closer and clearer on screens, on a video platform, as opposed to handing out hard copies at a meeting. So there are different ways to facilitate that discussion. And I think you're going to see at the board levels, when things improve, and they will, and you will have the ability to meet in person. It may be that the board finds that continuing a virtual ability to contact and meet with your professionals might make it more efficient and more frequent discussions that you have at different levels with all the A-team members that we talked about, that you can incorporate them into your regularly scheduled in-person meetings without them having to get on planes, trains, and automobiles to get to you. And that might increase the flexibility and the ability to meet with them and get into more specific educational formats on a more regular basis. And that might be a discussion that you want to talk to your board, with your professionals about. How does that translate to cost savings? There will be less travel, less cost, and maybe that does mean that they're meeting with you more frequently, and that doesn't increase the cost that they otherwise would have increased by coming to the actual meeting itself. You can manage and monitor that fee. You can manage and monitor that education. And at the end of the day, you're working both in person and virtually, electronically, to the betterment of your plans.
Okay. And it looks like that's about it as far as questions. And, you know, one thing we just always want to say at the end also is that we are, it's important that new trustees feel empowered. And we hope that's one of the benefits of sessions like this, that you feel empowered in the meeting to raise your hand, ask question. You are one vote on the board, but your one vote is the same as everybody else, a seasoned member, the chair, etc. And it is important for you to feel comfortable. If you don't understand something, ask a question. If you want more information, ask a question. And the providers that we were talking about, the assistants, the investment consultants, etc., their attorneys, they will be more than happy to spend some time with you offline to get you up to speed and make you comfortable. And going forward, hopefully this is going to get you off on a good start. So I want to thank you for joining us today. In case you missed something, or if you'd like to share this information with other members of your board or other new trustees that might have not come today, we will be posting the recording of today's, well, we're posting the slides on the MAPERS website. MAPERS is holding another webinar on Thursday, March 11th, and registration information is posted on the website, and the topic is the resiliency of non-traditional real estate. So this is a topic to talk about non-traditional real estate in today's environment. So a good timely topic for that. Many people have been asking about the spring conference, which is scheduled for May 16th to 18th at Soaring Eagle in Mount Pleasant, the conference center. And MAPERS is monitoring information and following all group and meeting guidelines recommended by the Michigan Department of Public Health. So regarding the virus. So the decision as to whether we are going to be able to go forward with the conference is going to be probably not until mid-March. So please pay attention, keep your eyes open for that. Okay, so on behalf of the MAPERS board, we want to wish you and your family and your colleagues good health and safety. And thanks for being here today.
Thank you.